Welcome all once again to the Heinz Legal webinar series. It's our regular deep dive into the weird, wonderful world of strata and management rights in Queensland. I'm Chris Irons, Director of Strata Solve. That's stratasolve.com.au. As always, I'm joined by Frank Higginson, Partner at Heinz Legal, the premier provider of legal advice to the strata industry in Queensland. Frank, hello.
Hello, Chris. Hello, everyone. Yet again.
What's been happening, Frank?
Mate, what's been happening is I think the Commissioner's Office has finally caught up with Austlii, and so there's a whole bunch of decisions getting uploaded there every other day. So because there's been a void for a period of time, they appear to be catching up. So been happening is I think the Commissioner's Office has finally caught up with Austlii, and so there's a whole bunch of decisions getting uploaded there every other day. So because there's been a void for a period of time, they appear to be catching up. So as always, there's some interesting reading in those if you are minded to delve into all things body corporate, not as specifically as what we're talking about.
You should be minded to delve into that because that basically informs where you go. We might actually do a separate session on that at one point, Frank, how to use the database of decisions. Yeah, let's do that. All right, there you go. Problem solved. Well, maybe not. But look, this week, we'll get on to our topic in just a second. Just a bit of housekeeping for everyone. For those listening in live via YouTube, you can post your comments in the chat. We always welcome those, and we'll try to get to those as we can. For anybody listening later on, so if you're out walking the dog or washing the dishes or whatever, you can find all the notes and links we referred to at the Heinz Legal page, heinzlegal.com.au. This week, Frank, we're going to delve. We always talk about who's who in the zoo in strata, roles, responsibilities, the different players in strata. One of the players that we haven't really touched upon a lot, developers.
No, and we should, because they are definitely part of the strata ecosystem. Because without them, we really wouldn't have strata, is the reality of it. Because I mean, and I suppose the legal term, the term that's used in the legislation is original owner. So that's the first person that, because before strata exists, we've got a block of land, 800 square metre block of land. On that is built 12 units, and until that building is created by a plan of subdivision, it's still just one block of land with 8 units on it. And the moment that plan of subdivision is registered, we have 8 separate titles on common property, and there is the bodies corporate that we all know and love. And the person that owned that block of land beforehand is the developer, and from a legislative perspective, the original owner. So without them, strata would not exist. And I think that's the thing. It's like, you talk about NIMBYism and all, not in my backyard and all that sort of stuff. But for me, it's a bit of a difficult one in the sense of, like, we all see people not necessarily doing the right thing. Developers, the same as lawyers, and probably not strata consultants, Chris, but I'll throw you in there, can do the wrong thing from time to time, whether intentionally or otherwise. So that happens. But there are an enormous amount of developers out there that do the right thing and continually do the right thing. So it's easy to see them all tarred with the same brush when it's actually not necessarily appropriate to do so. So, and with risk should come return, and in development there is absolutely a bucket load of risk. Rates, market conditions, construction costs, timing, banks, funding, personal guarantees, all that sort of stuff. So they're entitled to get a return, and they should get a return, because that's the capitalist system under which we operate. So having said all that, I suppose, mate, it's sort of back to the very, very, very macro view of this, and then down to it, because without them, bodies corporates wouldn't lurk around the way they are.
Absolutely, that's right. So as you were saying there, Frank, the term that strata legislation uses is original owner. There's also this thing called original owner control period, and we'll delve into that a bit more. We've got a link there to that definition of original owner, which we'll put up in the chat shortly, and you can have a look at that at your heart's content. Importantly, not only in the sense that the developer kind of gives life to the scheme, developer does some pretty fundamental things in doing so. They, for example, select the regulation module, which will apply from the start. They will enter into contracts with different people and different providers, and they'll usually hang on to some, if not a controlling interest in lots for in some cases, a considerable period of time afterwards, Frank.
Absolutely. It depends what type of developer. Some sort of get in, get out. Some do hang on for the long haul. And I suppose in strata, like a sort of controlling block is not necessarily 50% of the lots. It could be 20 if no one else votes. So you can get away with control without actually owning half of the building. You know, they also draft all the bylaws. They draft the management rights agreements if they're going to be there, and set up the entitlements. Work with strata consultants. You know, usually a body corporate management company to set the budgets and all those sort of things, and that's all disclosed to people when they buy off the plan. So, and that's one of the things. It's sort of, and we're going through this at the moment from a statutory review perspective in terms of disclosure and what's good, bad, and different, what should change, and all that sort of stuff. And so, when you buy a property off the plan, you get an inch thick contract usually that's describing the lot you're buying and the terms on which you're buying it, and you also get a parallel document which is the disclosure of what the body corporate's going to look like, because the developer's got to tell you what it looks like.
Absolutely, yeah. Let's talk about some of those specific obligations which apply to the. Are we going to go with developer, Frank, or original owner?
I think developer is what everyone refers to them as. Let's leave the legislation aside for the moment.
Yep, I think that's fair. All right, so developer it is. So let's go over some of the specific things, specific obligations. So one of the biggest set of obligations for the developer is in relation to appointing and engaging body corporate manager and caretaker, Frank, isn't it?
It is. And I think it's really important here to sort of note, and this is legislative really, is that a body corporate isn't owed what's called a fiduciary obligation from a developer. So a fiduciary obligation is the highest type of obligation you can have when you're in a relationship with someone contractually. So, and the easiest example is lawyers and clients. So if I'm acting for someone or something, being an entity like a body corporate, I must put their interest ahead of mine at all times. Full stop, end of story. So, and so that applies for lawyers, it applies for real estate agents as well when they're acting for vendors and probably a range of other professional services like that. That type of relationship doesn't exist between a body corporate and a developer. But in relation to contracts, service, the management rights agreements, body corporate administration contracts, the original owner does have a statutory obligation to exercise reasonable skill, care, and diligence and act in the best interest of the body corporate while they're there putting these things into place.
Yep. Okay.
Now, the difficulty with that is that, I suppose, two things, is that it's the developer's obligation to do. Skill, care, and diligence is obviously a very wide or capable of wide interpretation. And what's in the best interest of the body corporate is also capable of a wide interpretation. So, and I think probably the second part of that is, to the extent that a developer doesn't do those things, I don't think it necessarily invalidates the contracts or parts of the contracts that they might have caused the body corporate to enter into. It might give rise to a right for the body corporate to have a chop at the developer after the event to say, you didn't do what you were required to do at law. But that contract would still be binding. So defect in the legislation or otherwise, that's what it says. And that's, you know, from a obligations owed perspective, about as high as it gets in the legislation with respect to developers.
I think that's right. So that's section 112. We will put up a link to that section in the chat shortly. Another obligation on developers is in relation to insurance. We'll put up a link to that legislative provision as well. And effectively what it is that the developer must take out the insurance which applies to the scheme when they are in control. So everybody corporate in Queensland has an insurance obligation depending upon how the scheme is set up. So that obligation transfers over to the developer while the developer is still the developer, if you want to think of it in those terms.
And functionally, that's just a matter of cash flow, because the reality is that the levies haven't been paid by everyone yet, and insurance is probably one of the most expensive items of every budget. So the developer must pay that and then recover that from the buyers, usually in an off-the-plan context, as settlement adjustment.
Yep. Good point, Frank. And there are a couple, just in terms, we'll talk about obligations. This is less an obligation and more a restriction, but the developer there are some restrictions on the developer as they relate to powers of attorney. And one of the other interesting kind of obligations, and this is a relatively new one, only from March 2021, obligations on the developer to hand over, Frank, a pretty substantial list of documents.
Absolutely. So this is something that when we were talking about reviewing the modules, which, I mean, these modules are what, 2020 now, which is years ago. And so I suppose we're in the last decade, second decade of this century, talking about the review of these things. Previously, what was there was relatively light on. So now there's statutory obligations, and, you know, it's section 96. Everyone can just have a roll through that, but valuations, insurance stuff, DAs, development approval, which is a really big thing, plan specifications and drawings, Word documents of the CMS. So it's contracts for building work, which is really important from a defects perspective. And probably over time, that might be expanded upon a little bit, because in effect, what happens when the developer hands over to the body corporate, they are the body corporate for the first 14 days, usually at least. So everything that's in their mind, in a metaphorical sense, should form part of the body corporate's records, and that's what that section is driven towards putting into the records. Now, it's quite often that those things aren't there, but there's still a statutory obligation to do it. So I suppose from a body corporate management perspective, it's pretty important to make sure that you've asked the developer for those things, because they should be part of the records. And even, you know, like the POA, you're back to POA, power of attorney. Those things, there's a statutory cap on how long they last, but what they're designed to do is allow the developer to put in place all of the things that have been disclosed. Because what will happen is the developer will own all of the units for the first 14 days. At that stage, they can call general meetings and vote whatever they want through. But there might be circumstances where 6 months later, after they've sold a bunch of the units, they still want to put in place what they've disclosed to owners, but they don't have absolute voting control. So that developer's power of attorney, which needs to be disclosed to buyers off the plan in terms of this is what you're going to be required to sign, will normally allow the developer to do things to put in place what was disclosed.
That's right. And I think the crucial point to make about that list of documents to hand over, yes, the obligation is there, but if the developer doesn't follow through on some or all of that list, it's still up to the body corporate to take legal action. There's no capacity to take action through the Commissioner's office, for example.
And that is another shortfall, isn't there, from a jurisdictional perspective that should be addressed at some stage. But whether they get there or not will be another thing entirely, won't it?
Yeah. So developers have no standing insofar as the Commissioner's office matter is related, unless, of course, they're an owner, in which case they would. One of the main ways in which we tend to talk about developers sometimes is in relation to defects, Frank. So a recent, and so again, part of those amendments that came into effect in 2020. I said 2021 before, but I mean 2020. No, they came into effect in 2021. Just the name of the reg is 2020.
It's 20. Yeah, no, you're right. We're both right.
Yeah. We're both right. Yeah, there you go. So in this one, there is an obligation at the second AGM. So we think about it this way: we've had the first AGM has been held. So at the second AGM, there is an obligation to consider a defect motion. Importantly, the obligation is only to consider the motion. There is no obligation per se to actually get a defect report commissioned. It's quite feasible, for example, Frank, at that second AGM, that motion to get a defect report could get voted down.
Yes, and if it did, it's still on the agenda and the body corporate's done what it had to do. But I think this particular motion was to, I suppose, bring to the forefront the fact that there might be defects and everyone might want to look at getting a report. So, and it'll be interesting to see those flow through, because I suppose the first round of those motions is probably starting to appear a couple of years after. the modules, I mean, passed and then commenced. So yeah, it's
So the
interesting.
issue then, Frank, would be whether or not the failure to pass said motion would be unreasonable by the body corporate. And that will be an interesting one to see because there could be a challenge on that basis. And I guess more generally then when we're dealing with defects, Frank, that sort of enlivens then our old friends at the QBCC.
Yep, and how that goes then depends on a range of different circumstances. So, you know, like I suppose the QBCC sort of enforces, if you want to, again, very macro, building standards and things that haven't been built the way they should be. That doesn't take away a body corporate's rights to commence a civil proceeding for something that hasn't been done contractually. And again, what contractually was required depends on what the documents, what the contracts were, which the developer's obliged to hand over and sometimes doesn't. So I think for me, we've got a guide for bodies corporates facing building defects, which we'll put up as a link. So download that, feel free and have a read. That is very comprehensive.
Yep.
From my end, sort of defects, and it is interesting. So over the years, I won't name any names, but there's a couple of developers who I have seen who have a brand and have a reputation. And it's a good one in both circumstances. They have come back to do things that they weren't required to do,
Right.
without any doubt at all.
You're right.
So,
Okay.
like 8 years after a building had been built in one particular circumstance, this thing went wrong. It went wrong because of the way it had been constructed. Body corporate said to developer, come on a minute, have a look at this. Here's this report. Developer looked at report and said, you know what, you're right, we'll fix that. And that was a couple $100,000. So those type of developers do exist, and absolutely the other type of developers do exist as well, that have a shelf company set up, and the moment it's built, they sink it and away you go, and the body corporate's on their own. So I think from a committee perspective, dealing with defects is, you've got to understand the nature of the beast that you're dealing with, because developers can be particularly finicky creatures. Some are going to try to avoid liability under all circumstances. Some are going to try to protect their brand. To me, that's probably the starting point. And the ones that are trying to avoid liability and the conversation and duck and weave are the ones you really need to nail to the floor pretty hard in terms of, this is the problem, this is what we require you to do to fix it, and this is when we require it done by. Because otherwise, you will be pushed further and further out, and the issues don't go away. And I think one of the other things with building defects that bodies corporates sometimes don't understand is that the overriding obligation of a body corporate, amongst acting reasonably, is to ensure that common property is in good repair and condition. And that is independent of any right you might have to recover damages from someone who created that position in the first place. So you've got to do what you've got to do. You can't say we're going to sue the developer and in 5 years' time fix it. And then there's also arguments about mitigation, all sorts of things. You've got to do what you've got to do. And if you have the ability to recover that from someone else, then so be it.
I've been involved in a situation, Frank, where that scenario was made plain to a group of owners, and they were outraged by the idea that they would have to, the body corporate of which they were members, would have to be responsible for something that somebody else should have attended to. To which my response was, yeah, no, I'm totally sympathetic to what you're saying, but it doesn't change the fact that you're responsible for it. There it is. While this is about developers, Frank, we can't talk about developers, I suppose, without talking a little bit about management rights as well.
No.
We'll try not to sort of make it too detailed, because we want to get to one of the main points of this discussion. But Frank, in relation to management rights and developers?
Well, they've got the ability to cause the body corporate to enter into agreements, and they will do that in relation to and in accordance with the documents that have been disclosed to owners. So, because, mate, we've both had it where people will ring us after they've purchased a unit and say, I can't believe there's this 25-year agreement here. What can we do about that? This is the first I've heard of it. And the unfortunate reality is that, no, it's not the first you've heard of it, because it would have been disclosed to you when you signed up. And this is the difficulty with disclosure, particularly in something off the plan, is that, and this is, I suppose, the nature of the breed, again, of real estate agents, detail does not sell. What agents are selling when they're selling units off the plan, leaving aside, economic circumstances might be FOMO, everyone's wading in to 3 copies, press hard. Where's the nearest contract I can sign? Versus something that requires a bit more sales ability. But in either circumstance, the agent is not going to get the deal away by delving into what is in the paperwork. They won't talk about in the contracts usually about what the defects liability period might be for the developer. They won't talk about pre-settlement inspections. They probably will talk about levies, which is going to be a highlighted line in most disclosure statements. They won't talk about the management rights agreements or who the body corporate manager is or what the sinking fund forecast looks like, whether there's a Energex agreement with it and what the lift service contract looks like, because that stuff doesn't sell. So the reality is that right is there, and it has always been there. And I think our disclosure regime is relatively sophisticated, and I suppose in one sense, and I think this is probably one of the issues with longer term management rights agreements, because to me, more than like buildings need maintenance. They need people there to do the things that a management rights agreement caters for. The question about term is one part of it, but I think for me, most of the disputes come about A, poor performance, or B, control. So if you've got an agreement where control is effectively shifted off to the on-site operator and away from the committee, that is going to be a constant source of friction. Now, there is scope, and this is something that might be a surprise to people that are listening, under Section 130 of the Act, there is the ability within a very specified window for either a body corporate or a management rights owner to make an application for a review of a management rights agreement after that was entered into during the original owner control period within a window after that when you've got a proper advice. So that's your Section 130 is where it's all set out. I won't go any further than that, but you've probably got somewhere between 18 months and probably 3 years to do that as a body corporate, and after that, they're static. So the question, Chris, I suppose this is one of the things that may come up somewhere, is should there be the ability to have some sort of review of these longer term agreements 5, 10 years later? Because the reality is what the developer thought the building might look like and the type of people that might inhabit it when they're selling off the plan can absolutely change over decades.
Absolutely, Frank. Absolutely. Yeah. Well said. It's a pretty crucial discussion, that one. It's one of the crucial ways in which a developer has a role in relation to a strata scheme. I just want to leap ahead, Frank, because I'm a bit conscious of our time today, to what's happening. We keep talking about macro level stuff. So what's happening in Queensland is that property developers are now about to be reviewed, which is an interesting development. I can't recall that kind of thing happening in the recent past. What does that mean? Well, it depends, glass half full, glass half empty, or how cynical you are. So on one level, I reckon you can say, well, that's good. We've highlighted a few of the issues when it comes to developers, and governments recognise that too. So let's get all these things on the table. And let's find out some positive ways that it can be resolved. Of course, on the other hand, and as an old public servant, you never announce a review into anything without already knowing the answer. That was the old saying in the public sector. I can't imagine that's changed. What do you reckon, Frank?
No, I'd say it's fairly static, mate. And you've certainly got more public sector experience than me. So yes, I mean, it's the same, I suppose, when you're acting for clients to a degree. You don't want to go to a meeting and ask the question without knowing the answer, because you might be surprised. So yes,
that's right.
Don't disagree.
So look, we'll put up a link to the review documents for those of you who are listening or watching within that period, that the review is open and you can have your say. I think there is a reference panel that's been formed. I don't think there's a general document or a general call for submissions at this point. Strata, definitely interested in this. We're not represented on the reference group, which is a bit of a problem, but we will definitely, when I say we, the Strata sector very generally, of which you and I, Frank, are both part, will definitely be wanting to have a say on how that one all pans out. Do you reckon, Frank, there's a genuine will to reform? Do you reckon that there's anything meaningful or constructive that can come from that?
I don't know. And I really, hand on heart, I mean, I like giving yes and no answers, but, and I suppose it depends on the angle which the government approaches it. It's sort of, we talk about consumer protection and we talk about disclosure, and does disclosure protect consumers, or should consumers be protected from things that might or might not be appropriate? And that's the question for what's appropriate. Like, you come back to management rights agreements, because, it's sort of, from my end, I think, in a lot of cases, having an independent person there to provide effectively facility management services and run the thing, for which they paid money, which they owe a commitment to, means they're far more invested usually in getting an outcome that works for the building and themselves, than a bunch of committees who come and go, who get annoyed with providing free services, and then start jobs for the boys and girls, because we've both seen that a lot. So I really don't know what the perfect answer is, other than I'd suspect this conversation has been going on for decades, and this will be another chapter in that conversation. But I can't recall a proper review, as you're talking about, ever.
Look, I personally think there probably is scope to put a few more obligations on developers at those crucial moments where big decisions are being made, either particular obligations or some kind of mechanism to review and or extricate out of those agreements at a later stage, if the body corporate wants to or needs to. What those mechanisms are and how it gets done, that could be up for grabs. We talked about earlier how
compensation's paid.
We talked earlier about how a developer's not party to a dispute in the Commissioner's office. That could be a whole other jurisdictional issue to be opened up. Be interesting to see where that goes, because remember, from a political point of view, and you highlighted this right at the start, Frank, developers take on a fair whack of risk for a fair whack of reward in what they do. And let's also not forget that developers can and have done a role in influencing the political process, like any other stakeholders out there. They have interests in what the government should or should not be doing. They will pursue them as they're entitled to do, with some restrictions, it has to be said. But it remains to be seen where this all ends at the end of the day. But what I think it highlights is that there is an increasing appetite to understand better and to have greater clarity about the role of developers, and not just the role, Frank, but the consequence of what they do.
Yep, absolutely. And I mean, when you look at what they also do is you go through housing crisis moments. We had that the run up to the GFC, and that led NRAS and all that sort of stuff, which has now faded out. And at the moment, so we've got a lot of pressure on housing stock and people coming to Queensland, and where are they going? Because without developers building new product, they might as well shut the gate at the border, because there's nowhere for people to stay.
That's right.
And then from a social perspective, I don't think it's a matter of just jacking rents up by $300 a week, because where do the less fortunate in society stay? So there needs to be that constant reinvention of stock and production of stock and across the state. So we've got to be careful. You don't go too far one way and developers say it's all too hard, because if it gets all too hard, then Queensland, which always has had as its core development as a substantial industry, could be in for a little bit of hurt. So that's will be a really interesting conversation.
It will. It will. I hope this discussion has shed a bit of light on developers generally, because on that note, that really is all the time we have this week. You can find the notes and the links we've mentioned at hineslegal.com.au. That's where you can also find Frank, for that matter. Not literally there, but you can reach him there eventually. If you get through all of his minions. And you can find me, that's Chris Irons, at stratasolve, all one word, .com.au.